Friends, in session number 19 of the series on military law, it would be seen as to how the charges are investigated when any incident takes place. This may relate to a charge or in an incident, whether or where the culpability or the identity of the offender is not known. There are certain golden principles that need to be borne in mind before proceeding with the investigation of charge, and these are as listed on the slide in front of you. An accused is presumed to be innocent till proved otherwise. This is the presumption of innocence. The onus of pronouncing guilt is on the prosecution, and the benefit of doubt will always go to the accused. No person can be punished twice for the same offense. That is the notion of double jeopardy. No person can be a judge in his own cause. He cannot deal himself with an incident or a matter where he is directly involved or primarily involved. No person should be punished unheard, and a decision should indicate application of mind. Now, these are the golden principles that are invariably followed at the stage of the investigation and subsequent disposal. According to the dictates of military service, it has to be appreciated in the context of this series and including this session that accused would in most cases be a soldier, he is not a criminal. Then exigencies of military discipline warrant speedy disposal. A case cannot be allowed to linger on, and it is also relevant that Army does not have a separate agency for prosecution or for administration of justice. This is done by the usual Army personnel. The investigation connotes a minute inquiry, a scrutiny, or a strict examination of a matter or an incident. And in the context of ascertainment of facts, it means sifting of material and searching for relevant data, while the matter which is irrelevant should be ignored and that should not burden the mind or the records of the case. And investigation includes all proceedings under the criminal procedure for collection of evidence conducted by a designated officer, meaning thereby that firstly, the investigation can be ordered only by a competent authority, and it should also be carried out by the personnel who are considered fit or competent to deal with the investigation. Now, investigation, a probe can be under two main contingencies or situations. One, where a suspect or an accused is being, his role is to be investigated or probed. For example, a person has been found to have shot at a group of people or at a particular person, where it is known right at the threshold that the shooting was done by this person, yet it needs to be investigated. What is the reason behind it? What are the facts? Which weapon has been used? What was the intention, etc. And secondly, where an incident or a situation that took place has to be probed, where the exact offenses or the responsibility, the role of the offender is not known, and the investigations will bring out. Usually, it is the second contingency where a situation or an incident is being gone through. Now, in this case, charge, what is the charge? This needs to be borne in mind. We would see this subsequently, the use of the word charge. And the examples are To illustrate, the fight was started by X person. Y was the custodian of stores but was unable to explain the deficiencies, and Z lost his identity card. Now, the three situations are different. A fight has taken place in number one case by one person, say X. In the second case, it has come to light that Y is in charge or responsible of certain stores and he is unable to account for the deficiencies which are there. And in the third case, Z is a person subject to military law and he is found not having his identity card. Court of inquiry, when it is to be convened, ordering of court of inquiry to set it in motion is called convening. Now, where the faults or culpability of the wrongdoer is not known, that is one situation. That fault, who's at fault, who has done this is not known, and it may also be needed when, under the regulations for the army, RADSR as is commonly known, makes it mandatory that a court of inquiry has to be done. We would have a slide to indicate some such situations where investigation by a court of inquiry is necessary. The second point to be borne in mind is that investigation would invariably be done by two or more officers. In fact, it is three officers. They may co-opt some others who are experts, but they are not members of the investigating team or presiding officer or members of the court of inquiry. They may assist it as an expert. And this process of investigation is known as a court of inquiry. Now, it's a misnomer to call it a court. It's not a court because it doesn't have power to punish. It doesn't give a finding in that sense. Yet, customarily, it is called a court of inquiry. And use of interpreters may be made when required, when the witnesses who are to be examined, they speak in a language not in which the proceedings are being recorded, which is usually English, then interpreters may have to be sought. And don't call it a court of inquiry, but it is being called court of inquiry. It's a misnomer. Just to illustrate, in certain situations where court of inquiry probe is mandatory, it is so written under the rules or in a regulation. For example, if somebody is absent for a period exceeding 30 days, then a court of inquiry is mandatory. Or a person who had been made taken as a prisoner by the enemy and he is released, he is recovered, then in such case where a weapon has been lost or a classified, secret, top secret, confidential document has been lost, if fire took place and it has resulted in a major loss of property or life, and where death has taken place due to unnatural reasons or suicide, etc. These six are some of the situations when investigation by a court of inquiry is obligatory. Now, investigation is started, set in motion by the issue of a convening order, which means that a competent authority has to set in motion or convene a court of inquiry. It can only be done by a competent authority, which would invariably be commander of a body of troops. Others who are staff officers, they cannot convene a court of inquiry. The court of inquiry must state, it must mention what is the purpose, scope, and extent of investigation. These three things, purpose, scope, and extent, should be indicated so that a court of inquiry remains in a manageable time frame for the purpose for which it has been set. It must indicate who all will form part of the court of inquiry, or in other words, who would be the members, and the senior member is a Presiding officer, so the name of presiding officer is indicated and who are the members. Usually it would be 3 members or perhaps more. And it should obviously indicate the time by which the investigation has to be completed, or the court of inquiries have to be, copies have to be submitted to the headquarters or to the office which had ordered the setting up of the court of inquiry. Just in front of you is a specimen, an example how a court of inquiry convening order looks like. So para 1 says a court of inquiry composed of, as shown below, will investigate the fight and scuffle that took place during the football match between 29 Rajput and 209 Field Regiment on 28 June at Jhansi camp. So it would have made clear to you that the matter is some fight which had taken place at Jhansi between during a match between the two units whose name are indicated here. And it is maybe that some people got injured, some property was damaged, something happened during that football match, and that has to be investigated. The fight and scuffle that took place. Presiding officer's name is given, who's a brigadier, and there are 2 members whose names and particulars are indicated in the convening order. Now, I told you that the extent, scope, purpose of court of inquiry should be clearly indicated. So that would become apparent from para 3, which is the next para, and it is written, court will investigate and record its finding and opinion regarding, number 1, who instigated and initiated the fight, who's to be blamed for originating or start that he started the fight, what steps were taken by the officers who may have been present in that ground football match to control and diffuse the situation. Perhaps the fight took place between soldiers, then what did the officers do? So that's para B. C is nature and extent of grievous injuries sustained by various persons. Now during this fight, it is believed that certain people got injured. Now, what injury took place? And sequence of events that led to damage to government property, including vehicles and furniture. Now, maybe that during this fight between the members of 2 teams, certain government property or vehicles which were there, the trucks, jeep, etc., which were injured. So, the sequence of events need to be found out by investigation by this court of inquiry. That is the purpose. Then next para says provisions of Army Rule 180 will be duly complied. Now here the attention of the court has been drawn that you would comply with the provisions of Army Rule 180. What it is, we would see in one of the next slides. Date and place of commencement of inquiry will be decided and intimated by the presiding officer. In short, what it says that this convening order has been issued. Now the presiding officer will inform all others that I will start my work and the court will come into operation on this date, at this time, at this place. Evidence will be recorded on oath or affirmation. This is not always the case, but it can be done in certain cases, that the witness who gives testimony before the court of inquiry will be administered oath or affirmation. Court will record its findings, opinion, and recommendations. Now, opinion and recommendations are not asked in all cases, but in this case, it has been said that the court will give its findings. Finding is that fight, scuffle took place at this time. It was started by this time, by this person. He did this, that led to retaliation by so and so. Now, these are the facts. And lastly, it says proceedings in triplicate will be submitted to headquarters so and so brigade by this time. So this also needs to be indicated by when is the report of the probe needed. Now, investigation usually will consist of, if there is a written complaint made by somebody, it would be read by the members of the court of inquiry. They'll say, okay, yes, this is the matter. Now let us proceed further. Then the statement of victim, he may be alive, he may not be alive, he may be available, may not be available, that would be recorded. Sequential or logical statement of other witnesses would be. Now, the two keywords here are sequential, logical, and relevant. Now, court of inquiry are not stenographers that they would record each and everything which or what a witness says. It should come in proper sequence, and only relevant facts should be recorded. Any irrelevant matter, if being spoken by a witness, can be ignored. Material exhibits such as weapons, clothes, recovered property, documents. Now, these are all necessary exhibits. These should be taken on charge. And if there is any person which appears to the court that is a suspect or an accused, or he wants to bring certain witnesses in support of his assertion, that should also be taken on record. Then, if the court of inquiry is concerning a place of occurrence or an incident, then the team must visit that scene of incident. In the case at hand where the fight took place, the court should go and try and understand, take into account the evidence which has come in the context of that ground, that okay, the team was here, the vehicles were parked there, and the spectators were sitting here. So all that the court can duly appreciate and take it into consideration. And if there are civilian witnesses who are not army personnel, then they can be summoned. And how they will be summoned, the example of that is written under Army Rule 180 in clause 5. It may be vital to ascertain nature or extent of crime. Now, what does this mean? Just to explain, if nature of injuries have taken place, so whether it took place in the hand or in the elbow or in the thighs or on the kneecap, and how much injury. So where, how much? Or a person may say that I was immediately taken to hospital, X-ray was taken, it showed this, and I remained in hospital for 28 days or for 2 weeks. So all this would come within the nature of injury. Then material affected says, look, uh, injury was so severe that the blood came out, and this is the shirt I was wearing at that point of time. You look at the blood marks on this shirt. Or if it's an incident involving theft of rice bags, then the bags were of this size, and two empty bags were then recovered from that house or that room. Monetary value of the consequences of crime should also be brought out on record, that the rice bags which were taken away, their value of rice which was there was so and so at government rates. There may be a need to call an expert. An expert evidence may be needed when a forensic, handwriting, ballistic, cyber expert, or postmortem examination is desired. So if, say, a person had died, then the body was subjected to postmortem examination, the evidence of that doctor would be taken. Or if it was a handwritten document, there may be need to find out who's the author of that document, so a handwriting expert may be called. And also there is circumstantial evidence, if there, should be brought on record, that say for example the two persons went and sat down in that room. A sentry says that after that nobody came to that room, and 30 minutes later when a person came out, he was limping and he had injuries on his face, or he had this. Now the circumstantial evidence in this nature should also be taken on record. It is important that investigations must be done in the presence of, if there are any suspects, in the presence of the suspects so that they do not say later that this investigation was done behind our back and we were not allowed or given an opportunity to explain our version at that very time. Secondly, no witness should be tortured or forced to speak against somebody else. The statement has to come voluntarily and it has to be taken out by asking question and answers. Usually it is written the gist of the statement given, but where necessary the specific question and answer can also be recorded verbatim. And evidence should be recorded both in favor as well as against somebody who's a suspect at that court of inquiry. Now, I had mentioned about Army Rule 180. Now, what does 180 Army Rule state? It says what is the procedure? Now, it says that except in the case of a prisoner of war who is still absent, because if you are investing, how was he taken a prisoner of war and the person is not available, he is in the hands of enemy, obviously you can't get his statement. Whenever any inquiry affects the character or military reputation of a person subject to that. These are the two words. That inquiry is affecting that this fellow has behaved in a manner which is shameful or cowardice or sort of dishonest. So the person that person will be provided full opportunity, number one, to be present throughout. Now, since his character or military reputation is affected and it's being said that he carried out misappropriation of stores, so allow him to be present, number one. Number two, he may make any statement. Number three, he may give any evidence that he wants to give to explain his case. He may fourthly cross-examine any witness who's speaking against him or whose evidence is likely to be against him. And he can produce any witness in his defense. Now, all these are available under Army Rule 180. Now, these need to be recorded. The court does not record the questions just in a mechanical fashion. The evidence comes out by asking questions, and the questions need to be searching and probing. And it is important that the court of inquiry in its report should pinpoint and apportion blame. Where a crime has been committed by more than one person, then this person started, or he was the prime mover, he was supported by so and so, and then he was joined in by so and so. So the apportion blame needs to be, this exercise action needs to be taken. In the finality, it is impressed that a thorough and timely investigation, if it is conducted with dispatch and sincerity, will assist in law enforcement. Thank you.